Okay, let me call to order the Fox Canyon Groundwater Management Agency meeting for Wednesday, December 2nd, 2009. If you please rise for a pledge of allegiance. Ready? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. Roll call, please.
Chair Mulhart?
Here.
Director Craven?
Yes, here.
Director Kelly?
Here.
Director Borchard?
Here.
Okay, and Sam McIntyre is in the audience as an alternate, and I don't see any other alternates. Okay. Agenda review, any changes on the agenda?
Yes, a couple of small ones and one larger one. The first is on item 3, page number 1. Under the second major bullet point, where it says a users group meeting was also held after publishing the staff report, the date should be changed from November 25th to December 2nd. That was changed after this was published. In the back, we have 2 pieces of correspondence attached. One of the pieces of correspondence went to Crestview Mutual Water Company. In that correspondence, the table is in error. That's been corrected and should have been a copy of the corrected letter with the corrected table should have been given to you just prior to the board meeting. And then the last thing is it may be the case that your board doesn't need the closed session that we had scheduled for today, and we're asking whether or not you would like to hold that closed session in light of the fact that the tolling agreement's been signed, but there's been no other progress.
Sounds good to me to not have it.
Okay.
Where's the corrected Crestview letter?
It's my understanding copies were provided.
Okay. And we will not be going to closed session, so, right.
That's up to your board.
Yeah, okay, well.
And that's it.
Okay, that's it. Director Bennett is here. Okay. Public comments, opportunity for the... Rob's getting a head start on Henry.
Rob Saperstein for City of Oxnard. I'm half here to note that Steve Bachman's not here, and it's kind of timely with DWR issuing a 5% allocation for state water. Where's Steve's prediction for rainfall? I just want to provide the board some continuity. After our discussion at the last meeting over the resolution regarding the Faro property, Ken Ortega and Mike Solomon met with GMA staff, and there's discussion ongoing about potential revisions to that resolution, so more to come on that. I just wanted to let the board know we'd taken the offer to have more discussion, and that's in progress.
Okay, all right, thank you. Anybody else? Oh, Henry?
Following Henry Gromlich, Cayugas Municipal Water District, following Rob's good example on follow-up, at your last board meeting, Mr. Engel addressed the board, and since that meeting, Steve Bachman and I have met with Mr. Engel and reviewed groundwater elevations and the ASR, Cayugas' Aquifer Storage and Recovery Project operation, and we're continuing that investigation, but Mr. Engel is now assured that our operation isn't affecting the total amount of groundwater elevation loss that he's doing. We're providing regular updates to Gerhardt on our meetings with Mr. Engel.
Okay, all right, very good, thank you. Anybody else? Board member comments, anybody? I don't see in here on the agenda a direction that we were going to convene in closed session. It's your...
It's at the back.
Where is it? Okay, I got it on the wrong piece of paper. Okay, since this was published, you've sent a memo to the board members saying because the tolling agreement the necessity of having a closed session at this time. We really don't need it. It's up to the board. So I sent a letter back to Al. My position was then we don't have a closed session. I think you did the same. He didn't hear from other members. Are we all okay? No closed session? Okay. So there will be no closed session following our regular meeting. Okay? Yes.
Board member comments?
Yes.
I just wanted to wish everybody a happy holiday.
Very good. And what time is dinner on the 25th? We're supposed to be
1 p.m.
Oh, 1 p.m. There you go. If you can find parking, there you go. All right, anybody else? Any other board member comments? All right, we have two consent items.
Move the approval.
Motion to approve and a second. Any questions on any of those items? All in favor?
Aye.
Nays? Hearing none, so approved. Okay? All right. Informational items. Brian.
Afternoon, directors and audience members. Director Craven, you stole my thunder. I was going to wish everybody, being that this is the last board meeting of the year, wish everybody happy holidays and New Year. Item 3 is our routine update on the Las Posas Users Group and the development of a basin-specific management plan. Real quickly, there's been 2 users group meetings since the last GMA board meeting. There was one on October 28th and one held this morning. Previously, there had been one scheduled for the end of November. That one was canceled due to the Thanksgiving holiday. There's handouts from the October meeting in item 3A of your agenda package, and the statistics of attendance that we've been tracking are item 3B. You'll note that overall the attendance has remained steady. There was a slight dip in September again due to the fires, but in October we saw a rebound back to the normal group of attendance. During the October meeting, the main topic of discussion was Callegas's Aquifer and Storage Recovery Project in the East Las Posas Basin. Don Kendall, the GM of Callegas, gave a presentation on the ASR project. Real quickly, during his presentation, Dr. Kendall gave an overview of conjunctive use, the planned and coordinated use of groundwater and surface water, and how that relates to the ASR project. He discussed why the project was built and how it increases the reliability of water resources in the county. And he also described how the in-lieu delivery program is tied into the ASR project and how statewide challenges with drought and environmental conditions are affecting the in-lieu program and the ASR project overall. Also, during the October meeting, the group discussed the basin-specific plan and confirmed their prior consensus for seeking a 6-month extension. We'll deal with that under item 6. During this morning's user group meeting, the primary topic of discussion was groundwater elevations in the East Las Posas Basin. Callegas gave a presentation that included a summary of water level trends in the region, and this was to provide an update and also, as Henry mentioned, as a follow-up to the concerns recently expressed about dropping water levels in the basin. That concludes this update unless there's any questions.
Okay. Anybody else have any questions? All right. Very good. Item 4, Rick.
I'm just waiting for the presentation to come up here. Good afternoon, Chair Mohart, members of the board. For the record, my name is Rick Viergoots, and I'm going to be presenting item number 4 today. You may recall that during the September board meeting, we talked to you about the existing irrigation efficiency program, how it works, and some of the problems that we have with it. We discussed that it was developed about 17 years ago, and at that time the technology was still relatively new, and at that time we weren't able to put as fine a point on water requirements for the crops that we might be able to do today, and there were decisions made at that time to keep the program fairly general, and I think that was the right decision. Also, at that time, we knew that we were keeping things sort of general and that we would come back and at some point, after more data came in, that we would revisit the program. I also talked about how the program is designed to work. Growers report their total applied water, their irrigated acreage,
and then they go to the FCGMA website and they determine how much water is allowed for that particular crop for that year. I talked about some of the problems with the reporting. Sometimes the amount of water that's reported isn't quite right, or the number of irrigated acreage isn't quite right, and the calculation of the efficiency gets inflated, indicating that the actual efficiency is much greater. We talked a little bit about the allowed water that goes into the calculation. We talked to the academic experts about this. Dr. Faber said, yes, the allowed water that you folks use is a little bit generous. We described that we'd been working with academic professionals, Dr. Stiles from Cal Poly and Dr. Faber and Schwankel from the University of California, with ideas that they may have to help us improve the system. Ultimately, the board directed us to move forward with developing a scope of work and a proposal with these people. And this is just an update on that effort. And I want to talk to you just briefly about the goals of the proposal. First and foremost, to ensure the technical credibility of the program. It's critical. You know, we have 51,000 acres of irrigated agriculture in the GMA. And the GMA needs to be able to show that its irrigation efficiency program is technically credible and that it's doing a good job making sure that the calculations that we perform under it are accurate. We want to develop a better understanding of what crop water requirements are. Right now it's pretty general. What we don't break out are a few things. We don't break out old versus young crops. We also have 5 crop types that the program allows for, but we have many more than 5 crops grown in the GMA. The program allows for lemons, avocados, oranges. It groups strawberry, sod, and celery together, and then it has a group for vegetables. But we're not looking at container plants or other types of crops that are grown in the GMA. We're not looking at, or we haven't been looking at, whether or not hoop houses should be provided the same amount of allowed water, or other types of structures like that, semi-enclosed greenhouses. So this is something that the experts can help us with. We also want to revise the program to make sure it's both technically and administratively balanced. We're not interested in making it so precise that we know exactly, you know, let me rephrase it. We understand with 51,000 acres in the GMA, we have to keep things at a high level. But we still have to be able to show that our program is valid. We also need to make sure that the reporting that's done under the program is still appropriate for what we're trying to get at. Right now the reporting is fairly simple. There are some problems with it. Our intent is to keep it fairly simple. We did receive a proposal from Dr. Stiles. The approximate cost is $84,000. It includes an evaluation of past weather station data and a quality control check of it. Why? Well, we need to make sure that our historical data is correct. Dr. Stiles had explained that frequently these weather stations may report solar radiation incorrectly or humidity incorrectly, and those can skew the amounts of evapotranspiration that they're calculating. So we need to make sure that the historical data is correct. We also want to check the actual calculation that the systems do. I can tell you it uses a modified Penman equation, but I can't tell you if that's the best equation to be using today. We want to determine the weather station variability by year and location. To answer, do we need so many weather stations? Can we simplify it? Or do we need to maybe we need to add a weather station? One of the things that Dr. Stiles is recommending, since he won't be in charge of doing a lot of this work, or he'll be doing a lot of the work himself, but there's certain things that have to do with the UC Cooperative Extension. This is one of them. Learn more about farming practices for each crop. So this would likely involve Dr. Faber meeting with the farmers, talking to them about their irrigation practices, how much water they use, how frequently do they rotate crops, does the existing irrigation efficiency program work for what they're doing, are there changes that need to be made that the farmers know. Also, modeling crops to determine evapotranspiration values. Are we using the right amount of water for these crops? one of the things we talked about in September is that if we are allowing more water than what the plants need, maybe we need to look at reducing that. Learn more about the sources of water. This is one of the comments that Dr. Stiles made, is that some farmers may have, well, they will have higher TDS in some areas as opposed to somewhere else. Maybe those farmers need more water for leaching than other farmers do. Last two bullets, replace the irrigation efficiency term with another term. We talked about that some in September too. Maybe what we're going to do is call it an irrigation index or something like that. And finally, writing a report with the recommended procedures and zones and forms. So we believe the proposal's on track. We are suggesting some clarifications. We'd like it revised as a task-oriented proposal. In the event we want to fund certain tasks, but not every task. One of the things the proposal didn't include was Dr. Stiles' time to attend meetings. So we want to make sure that it's clear that we'd like his involvement probably at least at a SAG meeting and at a board meeting. And a little more clarity regarding the UC Cooperative Extension's role. When Dr. Stiles prepared this proposal, I think Dr. Faber and Schwankel were out. I don't know if they were on the holiday break, but we want to make sure that they give us their assurances that they've read through it and that they can do the work that's being proposed. So finally, this is our suggested schedule. We'd like to finalize the proposal this month. Also work with the Farm Bureau to publish a brief article on the effort. And I've talked with John Christ at the Farm Bureau, and that's something we can do. January 2010, we'll provide another update to you, and we hope to have the SAG consider the proposal from Dr. Stiles then or soon after. January through March, we'll need to do some outreach. Maybe what we need to do is make a few presentations to some of the users groups, or perhaps put a mailing to the existing irrigation efficiency filers within the GMA and tell them that we're looking at revising the program. And in March, we'd like to be back here with a staff report and with Dr. Stiles formally recommending that you make a decision on whether or not to fund this work. So that's all I have for now.
Okay, any questions for Rick? Anybody? Anybody in the audience? Yes, ma'am. I got to come up. I got to get you on the record.
This is my second question.
Hi, Dale.
Hi. I'm Dale Zarowski with the Farm Bureau, and my first question is very simple. Can you give me the equation again for irrigation efficiency?
Modified Penman equation is what we're using.
But I mean, it's total, you have your
this
applied,
one here.
Yeah, it's the total water over the applied water times the irrigated acreage or something like that.
It just happens to be in Ordinance 8, and I'll read it to you.
Oh, it's in there.
You should have it as part of your
Okay,
packet.
you know what, if it's in my packet, you don't have to read it off to me.
The formula is in,
I have another question too.
it was, now I'm going to make myself look like a fool. They originally put it in, where'd they take it in?
Oh, I have it?
It's not in there anymore. It used to be in there. I stand corrected.
It should be applied over what?
It's applied over,
Can we get this
the
out?
allowed water
Can we-
over the applied
Can we do this
water?
at the end of the meeting?
Okay, yes, we can.
Let me
All right,
do
I'll
that
go on
so
my
I keep
second
moving this
question.
thing along.
Okay.
All right, second question.
My second question is on this. What are the deliverables? It sounds like it's going to be learning. Do you actually have a deliverable in terms of getting any coefficients out of it for various crops?
Okay.
That's a good question. That was one of the things we want to put a finer point on, is exactly what some of the deliverables are.
Okay.
So, yeah, we're aware of that.
All right, very good. Anybody else have any other? Steve?
I will risk being misunderstood or misconstrued in terms of my statement here that I want to make, but I just, this is a receive and file. I'm not asking for any action on this or anything else. I just want to get it said that as an outsider coming in and looking at irrigation efficiency, right now it sort of feels very open to, like it feels almost unlimited, all right, in terms of irrigation efficiency. I just want to get on the radar screen that as we go through this, I don't anticipate this happening. I anticipate that what we get back in the springtime will be an improvement, and everybody will feel good about it, et cetera. But if what we get back doesn't start to really create confidence in my mind that that it will really address the issues of overdrafting of the basin, I would be talking about something that would be some kind of cap in addition to in other words, I might say, I don't care what the irrigation efficiency thing says, it's just not sustainable to have everybody use this for these crops. I don't know how that plays out or anything else, but I just want to get that on the radar screen as something I think ultimately there's X amount of water that we can take out every year, and we've got to get that into balance. And so to the extent that you've heard that at the beginning of this process rather than at the end, I just wanted to get that out there.
Yeah, good. I think that's a great point. By the way, 5.6.1.2.4 is the formula for irrigation efficiency in Ordinance 8. So if you have it. Okay. All right. Any other comments from board members or the like? The suggested schedule, let me comment on that. I'm okay with the suggested schedule. It's more movement than we've had in years of trying to face this issue. So anything that has dates on it is a good thing, and hopefully we can stay with that schedule. I believe that if we don't do a good job writing the parameters of this consulting contract, it will lose direction and basically hand us a big box of worms, and we won't get anywhere. And the issues that Steve raised then will be what we'll have to grapple with at the time. This is a complex issue, and having dealt with this issue some 20 years ago, or whenever we passed Ordinance 5, whenever that date was, it was so complex, we spent gobs of meetings, if John will recall, coming up with this formula because it was the easiest, safest solution to a very complex issue. So let's make sure when we write the task and we get everybody boiled down. I was surprised that 84,000 was the number. I think it's light because I think the problem is very complex, and hopefully at the end of the process when we get down to consider funding, we have a very well-defined set of parameters that we're looking for, and we keep moving the ball forward. So anyway, just
thank you for that.
It's going to be a big problem. Mike.
Mr. Chairman, in the beginning, I had thought that we, through Dr. Faber's efforts, we were going to be able to accomplish this, locally a bit better. But with the reduced budget, the UC system, Dr. Faber has become the catch-all guy. I mean, Sokovich is gone, everybody's gone, and he's the last remaining person. So to be able to get the other people in to help him, hopefully will get done in a reasonable amount of time, because I agree with everything that's been said so far. Being able to defend our position on what the numbers are is very important, and then we can go to the process that Director Bennett is talking about. Until we have defendable numbers, you can't tell somebody to live by the numbers. Yeah. Thank you.
Okay, all right. This is a big issue. It's been a big issue for us for years. We're finally moving forward on it, so I applaud this time schedule. Let's see if we can stick to it and make sure that we clearly define what we want out of this process, because it's important. Okay, great.
I've got one more comment.
Yep.
It seems to me in reading this proposal that there's a lot of data evaluation and kind of checking of historical numbers, and that's all good. And then, a review of what's found. But there's very clearly some field work to be done. And I would stress that part is probably some of the most critical work, because I think, as is going to be discovered, there are different water sources with different salt levels and different soils and different leaching requirements that are going to highlight the situation of irrigation and its efficiency a lot more effectively than we're doing now. And so I would stress, in terms of deliverables, that those kinds of things are very well defined, and that we get that information that's important to really come up with some good decisions.
Okay. Anything else, Mike?
Rick, were there going to be any graduate students involved as far as low-cost labor?
Dr. Kelly, I don't know. I don't know.
Because that's always, if somebody can turn this into a academic study, it assists in getting some boots on the ground to go around and check meters and crud like that.
Your assumptions may be false because the university is driving up tuition. There may not be low-cost graduate students that can afford to even do this. So.
Well, we buy them a good hot lunch now and then.
All right, very good. Yes, sir.
Quick comment. I appreciate David's comment, about the local conditions and all of that. And it just made me wonder if somehow we can make sure that, the property owners invite them to submit any information they have about their property, and then have everybody know, because I think that's one of the ways that you can always sort of improve your accuracy on this kind of thing, is everybody know it's going to be a public record, and everybody can look and go, wait a minute, that's not accurate what they're saying is happening on their property, or it is, because this would all be public. But to the extent that we invite people to do that, they know their property, and it would be a good starting spot in terms of what's going on out there.
Mm-hmm. Okay. All right, very good. Thank you. Let's move on to the next item, semi-annual outreach. Gerard?
Thank you, Mr. Chairman. For the record, Gerard Kapusik, Watershed Protection District and agency staff. I'm here to give you a brief overview of the report that's in the packet, transmitting a draft, and I would highlight a rough draft, of a one-page double-sided newsletter which your board conceptually approved to be included in our semi-annual twice-a-year billing statements for de minimis production costs. As indicated in the board packet, and more precisely in the draft that's before you, we've tried to be concise, credible, and cheap. At the same time, we're hoping that these topics are timely and will help agency stakeholders focus on some of the highlights that the board and the agency is grappling with, including the timing of the calendar and the request for annual nominations. The summary of the ordinance revisions, of course, will depend upon your action, but we would summarize those as well. So this is a rough draft. The board letter indicates that if you have any strong desires or comments on adjustments or additional topics, if you would be so kind, assuming you're reconfirming sending it out, to let us know by the 18th of December, and we'll make them. And these will just go out as part of our semi-annual sustainability. There will be no increase in postage. This is a de minimis cost. It's a useful tool, assuming your board still is committed to doing it. So I'd be happy to answer any questions.
Questions?
I got one suggestion. For this newsletter assumes that the reader knows what Fox Canyon Groundwater Management Agency does.
Right.
And it doesn't say that on here. So to the extent that this thing's laying around and people pick it up,
sure,
I would definitely put, you've got the regular board meetings, I'd put what it is.
We can do that.
We're in charge of, blah, blah, blah. Yeah.
Great comment. Thank you.
Put the name of the board members or something.
I think the names of the board members and a way to contact them, however we prefer to be contacted, is
or at least
good.
who we represent, and that
who
way
we
they know
represent,
how
yeah.
to.
We can do that.
Okay, good. Any of those suggestions, either from the audience or from the members, would be helpful. So, okay.
And if I can just take 30 seconds, the companion report, which was adopted or attached to this and is referenced in the lead article, is a really interesting and timely topic, published by, and I just copied it for you, the California Institute of Rural Studies, which is a collaborative of various agricultural interests, the Farm Bureau in the state, and it has case studies on very innovative water management practice by agriculture throughout the state. And in Ventura County, the particular case study was chosen as Limonera, but I'm sure there are many more. But it's an interesting report, and I commend you to it, given the topical discussions you'll be having on these issues. So,
is it possible to create within our web page a link that somehow could link them to this information and some headline saying here's some?
Yes, very much so.
Okay, might check into that. All right, very good. All right, let's go to action items. Number 6, Brian.
Again, for the record, Brian Bondi, United Water and Fox Canyon GMA joint staff. Item 6 is a proposed 6-month extension of Emergency Ordinance D for the Las Posas groundwater basins. Real briefly, as a reminder, the Emergency Ordinance D was adopted in February by your board It applies to the 3 groundwater basins in the Las Posas Valley. And the primary purpose for the ordinance was to create a timeout condition during which the basin-specific plans could be developed. The ordinance contains several temporary restrictions aimed at holding overdraft conditions at bay during the development of the plan. Real quickly, those restrictions are a moratorium on permits for new wells or replacement wells with greater capacity or new and increased groundwater use in the expansion area. Additionally, there's a 4 acre-feet per acre cap on irrigation efficiency filings. I believe at the December and October board meetings, user group meetings, Cayugas and the users group have discussed extending the ordinance by 6 months. We've mentioned that here, but I believe at the last board meeting, the users group and Cayugas have made significant progress in developing a common understanding of the basins and the groundwater management issues, but it's clear that the basin-specific plan will not be completed by the January 1st expiration of Emergency Ordinance D. As a result, and as mentioned, the group anticipates that extending the emergency ordinance would help facilitate the completion of that plan by maintaining the timeout condition, and they're looking for an extension to June 30th. They believe that we'll have a draft of the plan available for the GMA in June. Staff has reviewed this request. We do not see any major issues with moving forward as recommended or requested. We have no permit applications on files for wells in the Las Posas Valley. We have received some general inquiries about the ordinance. When's it going to expire? When might I be able to apply for a well? That sort of thing, but nothing concrete, certainly nothing in the form of an actual application. Therefore, we recommend moving forward with adopting the revised version of Emergency Ordinance D that's included as item 6A. You'll see that that's a red line strikeout version of the ordinance, and the only substantive change is the expiration date being changed from January 1, 2010 to June 30, 2010.
Okay. Any comments from anybody in the audience? Henry?
Henry Gromlich, Cayugas Municipal Water District. I just want to reiterate our thanks at the Las Posas Users Group and Cayugas for the GMA support for this item. We would recommend that you extend the moratorium. It's been very useful in terms of our ability to bring people together to try to find a new way forward. And in terms of new well, we anticipate that there will probably be some sort of new way of managing groundwater at the end of this, and insofar as wells represent an economic decision on the basis of the property owners as to how to operate that well, we think that it's really useful to them to be able to make that decision in the context of what the new management plan will be. And I'd be happy to answer any questions.
Okay. Any questions for Henry? Anybody in the audience? Anybody else have any comments? Thanks, Henry. Any board members? Questions? I support extending the moratorium, the emergency ordinance D. The user group up in the area is doing what we've asked them to do, what they've committed to do. We're moving that down the process. So having this moratorium extended while they work through that very difficult issue, I think is appropriate. So with that,
Move the approval.
motion.
Second.
Okay, motion and second. Any other discussion? Miranda, can I have a roll call, please?
Chair Mulhart?
Yes.
Director Craven?
Yes.
Director Bennett?
Yes.
Director Kelly?
Yes.
Director Borchard?
Yes.
Okay, let's go to item number 7.
Sorry about that. Excuse me. I think I'll be able to move forward here. Item 7. Item 7, we want to accomplish 2 things with this. First, I want to give you an update on additional task number 11 of the fiscal year 2009-2010 work plan, otherwise known as the Ordinance 8.1 policy update project, if you will. And then second, we'd like to recommend conducting a first reading and title of proposed ordinance 8.2, which would be the first in a series of multiple ordinance changes that we anticipate completing over the next year or so. In September, staff gave your board an overview of additional task number 11, the ordinance update project. And at that time, we presented a preliminary list of 13 potential topics, ordinance update topics. And we suggested that as we go through and bring updates, that we do it with 2 readings. At the time, your board directed staff to take those 13 topics, come back, group them into a couple sets, several sets of grouped topics for ordinance changes, and we've worked on that, and you also concurred with the 2 reading approach. You might recall, let me refer you to item 7A. 7A is an updated version of the list of the 13 updates that we looked at in September. Let me just briefly run you through what staff has worked on since September. You'll note that we added a new column here, date to board, that gets at the schedule or an idea of what the schedule might be for some of these items. We've grouped the ones highlighted in the gray color, which I do not believe shows up at all in your version in the agenda package. Those are topics 1 through 3, 5, and 6. You'll see that they have a date to board of December. Those are the items that we're bringing as proposed ordinance 8.2 today for first reading. The other items, we've scheduled several for potentially bringing in one form or fashion in first quarter, maybe second quarter 2010, and the remainder we've just listed as 2010. Those are the more difficult, complex topics such as credits and things of that nature. Too early to tell when those will be ready to come. So you may notice here that we've struck out 2 topics, number 4 and number 8. Number 4 had to do with adding language to the ordinance regarding inspection access. We reviewed the ordinance more carefully, and we feel at this point that section 3.1.6 adequately covers that already, so we struck that. Item 8 had to do with adding some language to the ordinance that dealt with laying out procedures for addressing complaints and violations. During subsequent staff meetings, we've agreed that that probably is better suited for the agency business practices manual that's currently being developed. So we're recommending not putting that in the ordinance, rather putting it in the practices manual. On page 2 of the table, you'll see that we've added 2 new topics, 14 and 15. These were added through additional brainstorming as we started working subsequent to the last board meeting. Item 14 has to do with penalty structures. This is in relationship to penalties for unregistered wells or failing to calibrate meters, so on and so forth. We've learned a lot of lessons this year dealing with the legacy issues with unregistered wells and meter calibration, and we feel that much of the groundwork has already been laid out for having a more formal understanding or description of what the penalty structure for those items is, and we're suggesting that that be added to the ordinance. Item 15, calling it definitions version 2, if you will. We identified a number of definitions between September and now that for terms that we believe probably should be better described or defined in the ordinance, but they're tough cookies, and it's going to take some time to work through those. So we basically took those out and put them in as item 15 here. Any questions on the work that's been done since September before I move on to the proposed ordinance 8.2?
Anybody? Anybody? Okay, so as we saw on the table, we're taking items 1 through 3, 5, and 6, lumping those together and bringing them to your board and the stakeholders for comments as draft ordinance 8.2. Let me just briefly describe each of these 5 topics, and I'll note that there is a red line strikeout version of the ordinance included as item 7B. That's where the detail on each of these can be found.
The first topic was minor edits. It's fairly self-explanatory. Staff went through the ordinance in its entirety and attempted to fix any typos, capitalizations, improve readability in some areas. There's no content or substantive changes involved with that. Those are fairly straightforward. Item 2, groundwater basin boundaries. This includes updating the definition of a groundwater basin boundary. That can be found as item 1.2 in the ordinance. The issue that staff raised with the definition of groundwater basins is that it referred to a set of recorded maps when in referring to groundwater basins, and as we discussed back in June, there is no such recorded map that shows groundwater basin boundaries. So we want to correct that, and at the same time add some language that describes that the board is going to adopt maps of groundwater basin boundaries by resolution, and in the future, if necessary, revise those maps via resolution. So that's fairly straightforward. Item 3, owner and operator information updates. Again, lessons learned here this year during the cleanup of the legacy issues. Basically, right now the ordinance does not require an owner or operator to notify the GMA except at the semi-annual statement period. Well, it creates kind of a chicken and the egg problem. If we don't know who to send it to, how do we send it to them so they can send it back and tell us something's changed? So what we're recommending here is just simply adding some language that proposes or establishes a 30-day requirement for an owner or operator to notify the GMA that there's been a change. I think that's fairly straightforward. Registration and reporting timelines, topic number 5. Again, some more lessons learned this year with the legacy issue cleanup projects. The ordinance does not require well owners to register wells within a specific time frame. We're proposing that we add a 30-day requirement upon completion of drilling activities. In some cases, folks install a well, don't necessarily intend to use it right away. Without a deadline, creates this gap in time where we don't know what's going on. They haven't registered, and that's how some of these wells get into the situation where they're unregistered and we don't necessarily know what their status is. So 30-day, recommending a 30-day requirement for that. The last item, definitions. This is chapter 1 of the ordinance. We went through every definition. We updated 11 definitions for clarity purposes, removed 1 definition, and we've added 6 definitions for terms that we found in the ordinance that we felt should be defined. Those terms include actual applied water, county, groundwater management plan, non-operating flow meter, ordinance code, and resolution. So at this time, the recommendations to your board are to introduce draft ordinance 8.2 for first reading in title only, direct staff to schedule a notice public hearing for potential adoption of ordinance 8.2 at the January board meeting. That'd be January 27th of next year. And we would request that public comments be submitted to GMA staff by January 8th of next year, should your board agree with the hearing date of January 27th.
Okay. Let me, first of all, go to the audience before I go to the board. I know Mark has some questions. Anybody have any comments?
Rob Saperstein again, City of Oxnard. Just one comment, item that Brian didn't call out in particular. It's on page 5 of the red line, section 2.1. There's an additional requirement to obtain a permit from the agency at the time of seeking construction of the well. New wells require a permit from the county, or in some cases from the City of Oxnard. That city still has permitting jurisdiction for wells within the city. I don't get the need to also come to the GMA for yet a different permit. What might make some sense is to provide the agency at the same time the permit application is filed with the county or with whomever that permit is required to be filed with, that they file it with the agency. But there's no standards here. There's no, what's the permit? What form do they use? What do they provide to this agency for which they're going to get a permit that is different than what they're already going to do for someone else. I'm just sensitive to just creating more bureaucracy for people to get themselves into trouble over unnecessarily. So.
Okay. Brian, and I guess we're asking to read the first reading. In between now and the second reading, you're going to accept public comments, and that means that we would make potentially adjustments going into the second reading. Does the second reading become a first reading all over again? Is that how that works?
Well, that goes back to the fact that there really is no first and second reading requirements. So if there were to be substantive changes made based on comments from owners and operators, it would be within your board's discretion to then schedule what would become a third reading.
Okay.
So I did want to mention one other thing. This needs to be corrected. If the ordinance is read in title at today's meeting, it is currently entitled an ordinance to adopt the code. It's actually, the ordinance would be amending the existing code, so that would be the correct title of the ordinance.
Given the fact that we obviously have one comment that Rob has made, and staff's going to have to deal with, either change it or not.
That comment can be addressed at this meeting.
Yeah, I can
discuss it too.
Okay, and
I can address that right now if you'd like.
Okay, go ahead.
If you look in section 2.2, there is the, I believe, word for word, exact same language that's been struck out. The change that's been made here is we felt that the paragraph 2.2 was confusing because it talked about registration and permits all kind of lumped together. We simply moved that pre-existing text about a permit out of the paragraph in 2.2 and up under 2.1 to make the sequence clear. You get a permit, you drill your well, then you register it. So this requirement is pre-existing in the existing ordinances, nothing new.
Okay, so it's just a administrative change in the way it.
We just moved the order of the
But
text.
still, why do we need it?
I guess the question is, why do we need a permit and a registration?
Well, the idea behind the permit is there may be conditions that are applied on that well, and it's in the owner's best interest to know what those conditions are before they make the financial or capital outlay to install a well that in some cases can be several $100,000 to install. It also gives us, so we know that a well may be installed, we know that there's a well potentially out there, make sure it gets registered and conforms with all the requirements of the ordinance.
And the permit that they acquire from either the city of Oxnard or from the county wouldn't handle those?
No.
They may not. They're wearing different hats at that time.
So they may not identify some of the requirements that we would be identifying for them?
That's correct. Yes.
So the major advantage here is it gives us an opportunity to have a conversation about any potential requirements that we might have. Can you give me an example of where this has happened and you've used it?
I can, but I don't have it at my fingertips.
Okay, then going back to my mistake. Go ahead.
Yes, Esper Peterson. Is that the county groundwater? There's nothing that prevented that, or would have conditioned that the way it was conditioned by the GMA. That's that's an easy example.
The Peterson issue is exactly the problem that was created. They permitted it, and we didn't know anything about it until the 11th hour, and it created all kinds of havoc for us.
And the conditions placed by the GMA would not be placed because they're not appropriate to the county groundwater relevance.
Got it.
The only unique case we have here is that the city of Oxnard doesn't go to the city of Oxnard is its own permitting process. From an administrative standpoint, we're not required to do readings per se. That's what you're telling me. Second of all, the changes you've made here, you've just broken it out into two separate paragraphs. So we haven't really changed the ordinance. It's what's been on the books for a long time. And even under that, if the city of Oxnard and Rob want to think about it, they still have a time frame in which to think about it, and we could respond to it and either change it or deny it or change to a third reading. There's all kinds of protocol that we can go through. So we're not locking necessarily into stone today
No.
the end-all, be-all. We're putting the ball in play to notice people. If you have comments, now's the time to make them, and we'll adjust them so that we have some closure to this time frame.
Yes, that's what we're proposing. I'd also add that we do have a SAG meeting tomorrow, and time could be spent discussing some of these issues as
Okay.
as
All right.
needed.
Any other questions or comments? From the board, who wants to go first? Steve?
I just want to ask, and it's a combination for our staff and our attorney, I like the concept in item 2.2 on page 5, which is you need to, you should register within 30 days. So, if you don't have a time limit, then it becomes meaningless. I just see the line, within 30 days, it is after the completion of drilling activities. And I just want to know, is that precise enough? Could a well be brought online, but somebody technically never complete the drilling activity and therefore use that as a loophole to get around this? Should we say from the beginning of the drilling activities, or 45 days from the beginning of drilling? You guys are more familiar with drilling wells. Do we need that level of preciseness, or is this adequate?
I know this language was developed by staff. I would frankly have to defer on that technical issue of whether a well that had started to be drilled was not completed would need to be registered.
I think we kind of have a practical way of tracking this, if you will. One of the benefits of having county staff in the GMA is that they also do the bulk of the well permitting within the county. They receive what's called a well completion form that is filled out by the driller. So we do have a way of back checking this. We know when drilling has been finished because the driller is required by state law to fill out that form. They receive the info. So we have a way of check and balance. We'll know that drilling has been completed because we receive the completed form. And the idea here isn't to hold people, you were 31 days,
Right.
Shame on you. The idea is just to make sure we get the registration complete.
My question is more in egregious. Is there a way to drill the well but not complete the drilling and have an operational well operating, and somebody say, hey, just don't complete that thing for the next year, technically? I mean, it may not be possible at all. I'm just asking the question.
I don't think so, because by state law that the driller is required to complete the form when they're finished with the project. And I believe, Rick, correct me if I'm wrong, but there's some time limits on how long they can have an open hole without completing a well or a partially completed project.
Thank you. All right, good. I assume that was the answer. I just wanted to be sure.
Okay. Mike, you had comments?
Yeah, mine is more of a procedural than a specific. I mean, I got this the other day and I started working on it. I sent my daughter to law school at McGeorge. She went 3 years, but I never got a diploma for myself. And I really, most of the stuff you send me, I try to read it as many times as I can until I understand it. But that still, I'm not capable of knowing all the correctness from a legal standpoint. I'm asking you, number one, my thought was that SAG was a place this type of stuff was supposed to be past the first hurdle before it would come here for the first read, and I'm asking why that wouldn't have been a good thing to have done. Number two is, we have authorized outside counsel of attorneys who are learned in the field of water. Have they been brought into this process at all, or is this such a simplistic begin that we don't need to do that yet? At what point are you going to begin to have outside counsel review this entire thing so that we don't find out that our house of chocolate cake is not going to collapse around us? So when's that going to happen?
To answer your first question about SAG, certainly it is within the purview of the board to direct this matter to SAG. I speak on behalf of staff. I think what we're trying to accomplish here is bringing, if you remember from the table, these are all the simple, what we're calling easy, relatively easy changes. Maybe we're testing the waters to see if the process works. Certainly, if SAG needs to be involved, that's something that can be done. In terms of legal counsel review, I believe this has not been through outside counsel. I'd have to confirm with.
No, we haven't even discussed that, and that, that's just Jeff's read on this board's sensitivity to the $325 an hour.
A good subject at this morning's Las Posas Users Group and is, I've forgotten now which one it is here on your list of things. Number 11 coming along. Item 11 is one more in the continuum of this, and yet there's some discussion, where we are with regard to case law and water law about outlawing the new use of unirrigated lands and those things. At what point
I'm sorry, I'm not on the same page, Dr. Kelly. Item number 11 is...
Item 11 appears on your page
of the
chart 7A.
of that chart.
Yeah, so I didn't finish my answer to your original question.
Okay.
These were easy, low-hanging fruit that we didn't think, Jeff didn't think, $325 an hour was justified. Certainly, when we get to the 2s and 3s, we're going to need outside counsel.
But my concern, Mr. Pratt, is that let's say we go to all the effort of correcting the language on some of this stuff, and they declare to you that the whole passage is incorrect. Why not have involved people to at least look at the stuff that you're changing as you go along?
We can certainly do that at your board's direction.
Because, some of the folly that we've enjoyed this last year, I think, is from not having things tied together correctly, and it's always fun to read about yourself in the newspaper. So the more correct and proper background we have on all of it is what from my standpoint, I would love to see, because there's a lot of question about what we can and cannot enforce, and to change the thes and nows and whens and wherefores and not get to the meat of the matter of what can we honestly impose on people and what conflicts with surface right holders' right to the water under their own soil. We need to come to grips with some of the basic stuff, and in my world, the sooner rather than later approach, rather than cleaning the house, let's find out if we want to even keep the house.
I'd like to speak to that.
Yes.
I can remember the last time we went through this. I can't remember all of it. We started the first time I was on the board for several years, and you guys continued while I was off the board for 4 years, and then I came back on the board, and it took another couple of years to get this, what we have now as 8.1. And then some other changes were made, and we realized that we needed to make changes. I had thought that as we were looking at the budget things and talking about how much we were going to do back in July, and I think that was continued to a special meeting in August maybe, or maybe it was September, we had told staff to take this in stages, and I think that's what they're doing, and we agreed to that. I don't really have a problem with making these changes. These are things that I've looked at them. I think it does clarify some things. It makes some things more correct. I don't know that any of this stuff was actually wrong for these particular changes. I don't think this kind of stuff does need a $310 an hour attorney to go through it. I think this is fine. When we get to the things that would have a legal question that can be challenged and things like that, I do think we need to have looked at. But I think even then, we need to take it in bits and pieces, because I don't know that any of us wants to go another, say, 7 years before we can get the whole bloody thing through. Because when we start changing, there's a whole lot of discussion, and I think it can be overwhelming and really bog us down. So I personally am in favor of taking this 2-3 steps at a time, especially with regard to the more controversial parts and the parts that we're going to have a lot of different opinions from the M&I folks and the farm folks and that kind of thing. Because I think, at least it was very difficult for me, and all of you have a lot more experience in water than I do, but it was really hard to go through and listen to all of the comments on so many different types of things, keep track of them all, and then come through in one meeting and say, this is what we want to do, this is what we don't want to do with regard to something .1 and something .5 and something else .1 and something else .8, if you get what I mean. So anyway, those are my comments.
Well, I'm not for breaking it up. I mean, for doing it as a lump sum. I agree with you. But I still think that we should, as we go, we should have somebody smarter than I am helping advise me on how I should vote.
I recall when we created the original base for this, Ordinance 5, and then later we got into Ordinance 1, and two of the key people that were part of the process of doing this modification, Rob Saperstein and John Matthews, so they can correct me where I'm wrong, and I will tell you that we spent literally hours, line by line, going through every one of these items, trying to make it what we think is right. And I will submit to you, Mike, that I think we have within our agency boundaries, representing some of our biggest constituents, some of the best water attorneys that, you know, they're top quality water attorneys. And I got to believe that Rob Saperstein and John Matthews are not asleep at the switch, and if we wrote something that is so far out of whack, they'd be the first up here to tell us, this is not right. They've been part of this process from the get-go. Now, what does that mean for me? It means that what we have in this agency is a system that we created ourselves. And I remember when we first passed the underlying ordinance, we had Stuart Somack, one of the firms that we've contracted with, sit virtually in that chair there, and I turned to Stuart and I said, tell us, we wrote this thing, tell us, does it pass the test? And his answer at the time was, you can write whatever you want, and if people will follow the rules, that's one test. Does it create new water rights? And nothing that we've done created water rights. It's restrictions on how we can use the water we have, and we have the authority to do that. And so I look back 20 years ago when I started on this agency, 20 plus years ago, when we did the underlying ordinance, and I don't remember what year we did it, it's all running together now. And I have said, you use the house of chocolate cake, I've used the house of cards. We have in front of us a house of cards. Any of us, from the single pumper to the biggest city, could file a lawsuit tomorrow and we're in adjudication. And we haven't done that. And the reason we haven't done that is because I believe the ordinance is fair, it's logical, it is not perfect, it will not, in my opinion, pass the scrutiny of 75 attorneys nitpicking it to death. I don't think it'll pass that. But I'm not prepared to have 75 or even one law firm throw it out and say start over again. Because the truth of the matter is, it does work. It doesn't work perfectly. We have a bunch of holes in it. We know there's a bunch of holes in it. And this last year, we got bit by some individuals that figured out how to drive a truck through it. And as I told staff the other day, I lose sleep at night worrying about the next guy that's going to drive a freight train right through the middle of our ordinance and bring the house of cards down. I believe that the process that staff went through to come up with the changes they've made here is an outstanding job. I think as we move the ball down court, we're going to get into some tough questions. And I think it's appropriate to have some legal minds supplement the kind of minds that we have in the audience right now that have actually been part of the check and balance that we've had over the years. So when you add Al and county staff, when you add John representing and specializes in water law, Rob with parent law firm, I mean, they're not jumping out of their seats saying, you can't do any of this. What they're saying is, it works. There are some holes. Let's clean those up. So I agree with Charlotte. I'm not prepared to spend a whole bunch of money handing it over to people that don't know what we're doing to tell us all the flaws in this, because maybe I'm afraid of their answer. But part of it is because they don't know how this ties all together. And for me, the biggest check and balance of this ordinance is the willingness of the constituents to follow it. If they're willing to follow it, and the biggest pumpers we have in the county, United, PV, Oxnard, Ventura, and others, are willing to follow the ordinance, and major growers are willing to follow the ordinance, it works. And to me, that's important. In our most recent case, we've had an issue with one of our cities, and they have been respectful enough to respect the power and the position of the GMA, and that's why we have a tolling agreement, and we're going to work that problem out. We've had two major growers, challenge us on whether or not they have the right to take water, and we have negotiated that process to a lot of it depending on what this ordinance says. So I'm very careful about turning this over to an outside law firm and saying, I want you to go through this top to bottom and give me a report, and if it's really crappy, let's throw it out, because I think Charlotte's right. We'd be here for 9 years trying to put it back in the bottle. I don't think we need to do that. I think we need to do some cleanup. We've done that in the first step. We've broken it down to small bites. I think we need to go through that. As we get into the really tough issues, I expect the attorneys that represent our major constituents, I expect the growers, I expect the mutuals that have real problems with what we're proposing to come up and stand before us and use the process that we've used over the last umpteen years, and we'll work it out, and we'll come up with an ordinance that we all buy into, and it'll still be a house of cards, but we'll all buy into it, and it will work. That's my vision, and I think we can get there. When we get into a debate between one agency and another agency on the legalese of a particular comment, that's when I think we need to have that law firm come in and give us some insight, independent of the emotion that we may generate, to tell us where we stand. And I think that's good use of the law firm at that point. And I'm willing to spend the dollars to get that answer so that we can protect this fundamental document that we all buy into. We're talking about doing a lot of work on efficiency, and Steve, I think, was right. People have real questions about the accuracy of efficiency, and if we don't get a handle around that, then our ability to move forward with rules and regs will fall apart. If people have debate over particular line items or particular concepts and we cannot come to an agreement on what that concept is, we need to have outside counsel, and I'm willing to spend the money to do that. At the end of the day, we need an ordinance that we all buy into, that works for us, that doesn't create case law, that doesn't create water rights, but is a system by which we have checks and balances so that everybody knows they're playing by the same set of rules. And I think the first draft that the staff went through, they got more done in their first draft than we got through in a lot of the meetings. I can tell you, and Rob's laughing there, there's a lot of meetings we sat through and we couldn't get through one half of a paragraph on 1/4 of a page before we pulled our hair out. This is complicated stuff, and at the end, it works. And that's where I lean on. The system works. I do not want to throw this ordinance out. I am cautious about turning it over to a bunch of legal beagles who can nitpick it to death, and they will. It doesn't get us anything. Right now, it works. Is it perfect? No. Are we going to correct it? Yes. Are we going to do it in sequence? Yes. When we get to the tough questions and we can't come up with an answer and come up with some kind of mutual agreement, the board is going to turn to outside counsel to give us some insight to see if we can break that logjam. Then I think the system is doing what it's supposed to do. So I'm pleased with this, and I would support putting a first reading in, going through the process that you talked about in early January for input, and if the input says we're wrong, we'll change it, we'll make it right, and if we have to do another first reading, we'll do whatever it takes. That's how we've been operating over the years.
Okay, I want to throw my hat in now. Chair, I respect your passion for this agency and your commitment for all these years, but I'm going to have to say that some of what I've heard you just say it doesn't make a lot of sense to me. But I think ultimately what I heard from you is that we're going to call in outside legal help when we think we need it, and I think that's the right way. I think what I heard from Dr. Kelly was that his opinion is we ought to get started on that review, and I don't think that's a bad idea. I think because of not having that review is perhaps some of the reasons why we got into the troubles we did in this past year. And so I've been advocating for that for a long time, and I do think we ought to get started on having a review of our ordinance. I think that's a simple thing, and we ought to hear that opinion. We don't have to do everything they say, but we ought to have that opinion. So I think that maybe some of what, in deference to Dr. Kelly, it sounded to me, some of that was taken out of context. I think staff's done a tremendous job myself as well on this initial low-hanging fruit stuff, and it's probably a pretty good way to continue to go about it. Kind of just get it out there and get the discussion going, and so I didn't find this too difficult to follow. I took out my copy at home and just kind of went side by side, and it seemed to make pretty much a lot of good sense to me. I did have a couple other questions that were kind of unrelated to this conversation that I'd like to ask. On this chart, item number 9, monitoring and contingencies, talks about possibly requiring specific monitoring and contingency actions that are tied to the BMOs. What is that?
In our groundwater management plan, we have a number of basin management objectives for both water levels and water quality. The idea behind those objectives are if you're meeting them, then the basin is headed in the right direction or is in a good state of conditions. What we're getting at here in number 9 is the concept is to somehow link those measurements of water levels and water quality to the ordinance. That might take the form of different requirements or policies related to allocations or credits based on basin conditions. So the idea is linking the indicators of the health of the basin to the rules. At the highest, that's the high level concept behind that. And you'll see that that's listed here as a number 2. Perhaps it's a number 3. But that's the concept. Does that help explain the idea there?
I think so, in a general way. My other question was on item number 2 in this chart. We're going to remove the reference to recorded maps that do not exist. When will they exist? Are we going to have that item to approve or vote on shortly, or that seems to be a pretty
that's an item that's a technical review item that's in progress with staff and the TAG group. It's something that we're hoping to bring first quarter, second quarter next year. What you would be asked to do is to adopt by resolution a map that depicts the groundwater basin boundaries. What we're doing with revising the definition here is 2 things: removing the reference to the maps that don't exist, and then also making clear that the board will adopt a map showing those boundaries, and in the future, if those boundaries need to be revised based on new data, that could happen also by resolution.
And then in the document, it seemed like we're talking about 2 different maps. One relates to the boundary, the other relates to the outcrop, or is it all one map?
I think you're referring to the definition for the Las Posas outcrop. In
a couple of areas I saw a reference to indication of where the outcrop was located, and in one instance I think it changed it from being the north side of the boundary to the northwest east sides, and I think that was a clarification.
Okay, I think you're referring to, correct me if I'm wrong, but the definition for the expansion area, chapter
that's not, yes,
1.14. Staff found upon review that the description of what the expansion area is in the ordinance was incorrect. The correct description or explanation of the expansion area is contained in the GMA management plan. We took that description from the management plan and replaced the definition that was currently in the ordinance to make it correct.
Okay, that makes sense. Anyway, is there going to be another map that shows that expansion area?
That map actually exists.
It does?
It does.
So we can vote on that in January?
That's a great question. Staff would have to go back and research if those maps were ever actually adopted by some action of the board. I don't know the answer to that question.
Maybe it doesn't require a vote, it just requires to be recorded, right?
My recollection is that they were all part and parcel, the basin boundaries, the expansion area, but we can get back to you with and so you'll see it, but it will all come at one time, not in pieces. And that's my recollection, but we'll confirm it for you after the meeting.
Great. I'm glad to see you guys moving forward on that. I think that's really a very, very critical item for this agency to have in place. I'm finished.
Okay. Anybody else have any other comments? You're asked. Oh, Rob.
Steve?
Okay. Rob, come on.
If it's appropriate for more public comment.
Yeah.
I want to respond slightly different angle to Director Mulhart's comments. This ordinance code and the overall structure of the agency is really a creature of its constituents, and it lives and survives by the cooperation of the constituents. So all of what Director Mulhart said is really true. And when you get to the level 3 items, I'll give you some examples. When you start to talk about potentially limiting access for overlying owners to irrigate previously unirrigated lands, that's, I would suggest to this board, a subject of negotiation among the community here, rather than going and asking a bunch of lawyers whether you can do it. It's more appropriate to have discussion among this community of folks that will either agree to be regulated and agree to a new set of rules, rather than going to lawyers and asking them what their opinion is, whether it can be done or not as an abstract notion. There are a couple other examples of sort of those level 3.
Could I interrupt you for a second?
Sure.
How would that be done if it wasn't done in this ordinance? How would a community agreement be pulled off?
If it weren't in an ordinance?
You just mentioned this overlying landowners and water rights, and that's not an advisable way to go about it by putting it in our ordinance. How would that be done?
I'm not suggesting it's not an advisable way. There are other ways to do it. There are other examples of how it's done, but the way that this organization has promulgated its rules is through the ordinance code. So that's my expectation, is the first try would be negotiate what we think are appropriate and acceptable rules to get to where we want to be, which is achieve a balanced overall management of this basin within some manageable parameters, and then embed those rules within the ordinance code. There are other ways to do it, but that has been the norm for 20 years of this organization. We've gotten there through negotiating those tough issues first, then working on the language following the negotiation. I would expect that's the way that process is going to occur for the more difficult issues. This first level cut, staff's done cleanup on the ordinance. They're not big issues, it's just cleanup. Do we need to do it now? No. There's nothing that I see as a part of this first cut that's crucial, sort of a make or break in the business of the organization. If you do it today, if you do it next month, not big deal. The difficult ones are to come. And I would encourage you, rather than spending lots of money on asking lawyers abstract questions, that you at least give them very defined projects if you're going to ask abstract questions, rather than handing them the ordinance code and saying, is this legal? Well, it's really a far too broad question, and you'll get an unsatisfying answer. I've been asked that as a lawyer too many times, and the response is, that's not really the question you're asking me. You're asking me what are the rules to achieve a certain objective, and I'd suggest that we focus either at the SAG or in these meetings, separate set of meetings, on what the next level of objectives for this organization will be, and then start working on how we achieve those outcomes. Credits, management of credits, accumulation of credits is an issue. How we might move to the next level of irrigation efficiency and control of agricultural pumping, and whatever else the other pieces might be, I would suggest come up with that very short list of items that need to be addressed, come up with a process, and when you need it, rely on outside counsel to give you advice on whether we're charting a course if there's conflict. Otherwise, I don't. It doesn't need to be me, it doesn't need to be John. There are lots of folks within this community that have had lots of experience in other basins. Steve Bachman in developing management plans for half a dozen or more basins throughout the state, where you've got enough experience, but each geographic circumstance and the resources available and the constraints available and the makeup of constituents are all unique, and so the circumstances need to be designed to meet their objectives. I don't mean to be abstract, but...
Mike has a question for you.
No, well, I just opened Robert State here.
Or Steve.
If you'll just hang on for a second,
Sure.
tell Director Bennett to ask his question, because I wanted to just ask one more.
Go ahead.
It seems to me that getting a consensus, would you not have to have 100% concurrence on a consensus issue in order for it to overwhelm case law that's been established in other places?
And I'll go to the backdrop of that question. So what you're really asking is make a risk assessment about if we adopt an approach that 100% of the folks don't necessarily endorse, what's the risk that those small faction of people might challenge that approach? Different way of asking what you just asked. And that's a risk assessment that's based on what's the objective, who it is that's complaining, and what the level of risk is to the overall organization and the structure to use the majority rule. This organization has attempted, whenever possible, to develop a consensus where everybody walks away feeling roughly satisfied. That doesn't mean happy, but roughly satisfied. It's worked so far. There are some really difficult issues coming up that you may not get there, and I just suggest that you deal with those instances more specifically, because you'll get lawyers who give their opinions on abstract issues that you'll be left, okay, well, we still don't have an answer.
So your suggested pathway is to go ahead and pass things which in some views might be questionable, and then await challenge?
Again, you're stating in a very general way what I would say is a little more complex mathematics. So you go through the process of negotiation and developing language and making an assessment about what's the likelihood, if you don't have everybody shaking their head up and down, that we can accept this. What's the likelihood of somebody really waging a challenge on it? And if you're worried about that, then you ask the question, can we defend it? Are we satisfied that this is an appropriate rule that fits within the confines of knowable legal constraints? And then you make another risk assessment. It's an iterative process, but I know if you went and asked Stuart Somack or I don't know who at Downey Brown, Scott Shapiro or David Elijah, an abstract question, are there circumstances in which you can constrain overlying rights? The abstract answer will be yes, but the devil's in the detail, and we need to work on the detail before you'll get a satisfying answer from anybody, whether you've got an approach that is going to withstand.
I think, Mike, and if you go back through our history, even when we adopted the first ordinance that says that you got to have meters, and then we had an ordinance of ordinance 5 point whatever it was, we never got within the audience 100% consensus. We never got that. We went through this public process, this open forum process, and we bannered it around, and we went through the 19th reading, and people would come and go out of the meetings, and over time the majority consensus was this is good. I don't think we have consensus on Ordinance 8 totally today. I would agree with that. But I think when individuals do things that are outside the norm as defined by what the majority has said, they don't want to live outside the norm, as long as they're not so shut down in their business that their risk assessment is, you know what, we can live with those parameters, we don't agree with them, but the cost of us fighting it and taking on the whole community is not worthwhile. And in fact, if you look at some of the issues that we've had, we talked about the collective power of the mutuals and the water community and the cities teaming up with United to say to certain pumpers, you can't do that. And I think we prevailed in the process. We didn't put them out of business. There is an expense. We got them back somewhat into the fold, and we left the ordinance pretty much intact. And we've done that over time. And I think that's what Rob is saying. So the idea that we're going to get 100% consensus is wrong. The idea that we are going to deal with some of these tough issues and negotiate some kind of long-term solution, and my personal responsibility as a board member is to say, hey, the solution that we just negotiated never will get us to safe yield, and the agency will never meet its objective. Now it really is going to get tough, and when we get into a legal question, we're going to have to ask a legal opinion at that point, and now it's a specific question.
I have a question along this line. We're a different critter. As I understand it, there's no other agency so far in the state to do what we're doing, but as I understand it, the governor and the legislature are looking at creating agencies somewhat similar throughout the state. So we were set up to do something that other areas of the state don't have an agency set up to do. Considering that, as well as Dr. Kelly's comments, and I think that he's coming from a place, correct me if I'm wrong, where we could have somebody look at this and say, water law and legal cases have decided that this is right and this is wrong. Now, my understanding was that water rights and water law was something that's kind of a theory, but it's really kind of loosey-goosey, and it all depends on who decided what, where, and there isn't a thing, any place that says this is right and this is wrong, and it holds throughout the state. What are you...
It's one of those broad questions.
Yeah,
it is a broad question.
And I can give you certainly, I think, a straightforward answer. First, there are actually another dozen agencies like this that are created throughout the state. So there are groundwater management agencies that are specially created, have special legislation like this agency does. They all function slightly differently. To my knowledge, no other agency has done in the way that this agency has done, created an allocation and credit system quite the same way that this agency has done, but they each have their own rules. So not quite true that there aren't other examples. So, and that's slightly comforting because we're not one of a kind. Sometimes one of a kinds are easier to pick off. Water law doctrine is like any other legal doctrine. There are very well-defined black line rules, and there are gray line rules. And give you an example. There are very defined parameters of overlying rights versus appropriative rights in a groundwater context. I can tell you what all those things are. Those are pretty well defined over 100 years of case law. There are other areas like constraining overlying rights that there aren't very well-defined cases, and they're very fact-dependent. And that's the loosey-goosey piece that's difficult. So each case has to be decided ultimately on the weird factual circumstance, and that can be very frustrating when you ask somebody to give you a straight answer and they say, well, tell me what the facts are, because it can vary. I give you, if I can make two other short comments. Just the fact that this agency has an allocation system and the credit system that it does is an example of what Director Molhart suggested, as there were folks that walked out of the room very dissatisfied, City of Oxnard being one of them. Quirk of history, during that base period, the City of Oxnard imported a vast majority of its water supply, didn't exercise its groundwater rights. There is doctrine under existing California statutory law that says they should have been given credit as though they pumped their groundwater rights for the use of that imported water. The decision by this board at the time was, Oxnard, you don't get credit. You don't get groundwater pumping allocation for the imported water that you brought into the agency. Thank you very much. You did a nice thing for the agency by not pumping groundwater, but it's not part of the City of Oxnard's historical allocation. The city was very dissatisfied, but left the room saying, we'll live within the rules. Could they have sued the agency and had statutory authority on their side to perhaps deconstruct what was a brand new construction? Yes. Were we representing them at the time? No. Had the world changed at the time?
Snuck that one through.
We were hired shortly after the decision was made to be satisfied. So, and so I use it as an example of that's. I suggest you work that direction. That the attempt to negotiate those outcomes and see. And if you always go back and reevaluate. If you're threatened with a lawsuit that you then determine has merit based on outside counsel, all the other folks that have a stake in it, you make a different decision.
Well, I appreciate your counsel, and I'm glad that you're being paid by others than us. But I just, usual and customary for an agency doesn't necessarily, for an area, doesn't necessarily make it law.
Yes.
And it may be fine to have polygamy in North Arizona, but I don't think that that's going to get very far in many other places. So that being said, if you start out in a task and you can follow within the known confines of existing law, you're probably less likely to be confronted, is the only point I'm making.
And so my only encouragement to the board and staff in looking for outside counsel advice is be very specific about what it is you're looking for, or you'll be left unsatisfied. You'll get generic answers that just won't solve your problem. And I, my last statement, sitting in the meetings with John, with former executive director Tony Waters, Director Mulhart, I was one of those that continually brought us back to, the fundamental premise here is ag is going to be treated differently than M&I. We will make available to agricultural users reasonable amount of water to allow them to survive in this county. And if that's the premise we're starting from, that directs us to a different set of outcomes than if we're going to rely just solely based on common law in California, common water rights law in California. Leads you to a different outcome. And so we're at a place, I think, where it's important to reevaluate some of those fundamental assumptions for the agency. It may be that you come back with the same underlying foundation construct, but I would encourage that conversation to happen at the local level, whether you want to have your outside lawyers in the room or not for that discussion so they have the context. That's up to the agency. City of Oxnard's not interested in paying yet more lawyers to be a part of the process because they feel as though the community has the knowledge, but that's the board's choice. I just would encourage that discussion first before spending lots of money on lawyers.
All right, very good. Steve, last?
Yeah, sorry, but everybody's weighed in, and we're sort of at a 2 and 2 here in terms of outside. So but there's two. I think there are two questions in front of us. One, do these, quote, level 1 easy changes need to be reviewed by outside counsel? My answer to that is I think they're straightforward enough. I think we had enough attorneys' eyeballs on this that if there was a gross violation of known existing law, somebody would point that out. The other question is, do we need outside counsel? Or I hear a request saying, hey, we need to get outside counsel brought in here. And I'd like to offer these responses to that. One, I agree a lot with what was just said about we deal with attorneys so often in the boardroom every Tuesday, and I can just tell you that it depends on how you ask the question, what answer you get from the attorneys. And the exact same case, and we can get the attorneys to flip and say, well, if you want me to make the argument about why it's illegal, here's how I would argue that case, and if you want me to make the argument about why it's legal, this is how you take the same facts. And it's just so to just think that we just hand this and say, what do you think? There's absolutely no way I would support that, and I'm not saying that's quite what you're saying, but I do think we have limited resources, and you can burn them up really fast on attorneys if you get into all kinds of issues. I only want to use those outside attorneys to ask very specific questions that will help us accomplish our goal. And if we're not exceedingly clear and specific, as Rob said, we will get unsatisfactory answers. And I've over and over again, I've sat on legislative bodies that have gotten those kind of answers from the outside. So I strongly believe we should focus on cooperation. What's the goal? I thought I was going to use that same example. I mean, the goal of Fox Canyon, the little bit I knew about water when this was all going on, I said there could have been fights from the very beginning saying you can't do this because of existing law, but people would have spent, we could have spent decades probably fighting this out in court also. So you got to start with cooperation, and then when you say the known confines of existing law, in my mind that's pretty easy if you ask the questions right to say, okay, this is what we're negotiating. Now if we say we want to be sure, we give this to somebody and say, don't tell us generally what you think, but does this comport with the known existing? And I think that's the time that I would think it would be appropriate to do that. So I hope that just helps clarify, so we're not, at least we're...
I think we're going to get our opportunity. We passed the extension ordinance D, which includes a restriction on the right to drill wells, and that'll come up again, and then that gets to be the question. And so I think we're going to have an opportunity to ask that.
Sure. Staff has made a presentation. The recommendation is that we authorize them in title only to have the first reading of ordinance 8.2. Is that the request from staff?
Yes, and to direct staff.
Did I say it correctly, Al? That's what.
To bring it back at the next meeting.
Yeah. Okay.
I'll so move.
All right. There's a motion.
Second.
And a second. Anybody else have any other questions or comments? Can I have a roll call, please?
Chair Mulhart?
Yes.
Director
Don't we need
Craven?
the reading?
Oh, do we read it first, or give us the procedure?
Yes, the title.
Okay, read ordinance. Who makes that reading?
Tammy does.
I do.
Okay. Miranda? Read ordinance 8.2, an ordinance to adopt Fox Canyon groundwater management. To amend an ordinance to amend the Fox Canyon Groundwater Management Agency Code.
You just read it.
No, but she has to read it. She's the
Okay,
clerk of
I'm
the board.
sorry. I'm a little lost here.
Write the first line under ordinance.
Okay, it's not what you usually read here.
No.
No.
Okay. I make a motion?
No.
I'm so
No,
confused.
here's it.
You read
There's a
it.
motion, a
I read,
second.
okay.
You have to do the
Amend
reading.
ordinance number 8.2 at the next meeting.
No.
No.
Here's what I want you to read. You got to say it because you're the clerk.
Okay.
Ordinance. See right here at the top?
Ordinance to amend.
See? Ordinance to amend, okay?
Okay, instead of, okay.
To amend the Fox Canyon Groundwater Management Agency Code.
Okay.
All right, just read that.
An ordinance to amend the Fox Canyon Groundwater Management Agency Code.
There you go. Okay, now roll call, please.
Chair Mulhart?
Yes.
Director Craven?
Yes.
Director Bennett?
Yes.
Director Kelly?
Yes.
Director Borchard?
Yes.
Okay, very good. All right, let's go to the next item. Hey, Brian, why don't you stay right there, and let's deal with the next item.
I'd be happy to, but it's Gerard's.
Oh, I'm sorry. Oh, I got myself one ahead of it. Yeah, there you go. All right.
Good afternoon, Chair Mulhart, members of the board. Again, for the record, Gerard Kapusik, Watershed Protection District and agency staff. I'm here today to present the first quarter budget performance report for the fiscal 09-10 budget, which your board adopted at the August 21st special meeting. Oh, sorry. The presentation today is basically in the standard fashion to provide your board with a dashboard of 10 indicators of the budget performance and therefore fiscal health of the agency. And we'll go through them fairly quickly. Overall, the fiscal health of the agency is sound. Budget performance is on or better than track. Essentially, as you see here in the standard format, we break up the major performance components. The agency had just over $2.1 million available from all funding resources to fund operations through September 30th. Approximately 1.6 of that was carryover balance from 09-08. Through the first quarter, a total of $567,000 in operating revenues from pump charges, surcharges, penalties, interest, miscellaneous incomes were received. That performance is about 11% over the target figure for the first quarter. Expenditures in the first quarter were slightly over, but that includes the amount reserved for contingency, which may or may not be spent as the year goes forward, but it's above the budget line, so we have the capacity to spend it at that point in time. So we're really very close on track. If, based on the first quarter data, everything plays out for the remainder of the year as we now know it, the expected year-end fund balance will be just shy of $1.8 million. And we have a slide at the end which will identify the components of what that balance is likely to be if the performance occurs. And that's about 125% of the target figure which we had originally projected. The underlying issue here, or the underlying driver of this higher revenue performance, is pumping, both in terms of standard pumping and surcharge. And we'll go through that in a moment. This simply just identifies, in terms of our operating revenues, the performance against the metrics. And what this table does is, on the left-hand side, lists the components of our operating revenues, which from top to bottom are extraction charges, surcharge, interest, GEMS revenue, which of course is no longer there, and total operating revenues. The first column on the left just gives you a baseline of what over the last 3 years the average has been. The next column is what's in the adopted budget of this current year. The third column is the actual amount that we received in the first quarter. The fourth column is just an expression of what that amount is of the total annual target. Anything higher than 25%, you're earning more revenue than we had targeted, we thought we would earn. And as you can see, the bottom line is that through the first quarter we earned $567,000 of operating revenue, which was 69% of the annual target. Now that's well over 25%, but remember, we basically receive our revenue in two chunks because of the semi-annual period. So this revenue is driven by pumping that was reported in the first 6 months of calendar year 2009, what we call our 2009-01 semi-annual statement period. And that's roughly 45% of our revenue historically. So we're overperforming what we've historically received. This just breaks down in terms of the pump charge for that reporting period, the first 6 months of January through June, which we actually received in the second 6 months, which is the first quarter of our fiscal year. We received $229,000 of pump charges, representing about 56,000 acre feet, and a slight amount from previous years where people just had lagged payments. Just for purposes of placing this in context, for the first pumping period in the calendar year was 56,607. On average, through our 1991 to 2008, it's called a managed extraction mean period, essentially when the rules have been in place. In that first period, it's averaged just shy of 50,000, so we're about 6,000 acre feet higher than average during that last 18-year period. And that's the current calendar year. It's the 8th highest out of the last 18 years for the first go-round. And as we get the second and the third quarter, we'll populate the table and continue. Letterman style, top 5 operating expenditures for the first quarter. As you can see, with the exception of PWEC, which is slightly higher than the 25% target, but that's a reflection of the amount of activity that's going on. But we're basically overall on track in terms of the first quarter. There was only one contingency transfer that your board authorized when you adopted the database. You conceptually authorized $150,000 of the $250,000 to be earmarked for database in 50,000 increments. The first increment was in September, and so we moved that from contingency to that line item per your board's direction. So again, we're projecting, if everything holds, on June 30th, almost 1.8 million fund balance, which is about 25% higher. And if that comes to pass, this is the component or sources of that fund balance. The single largest source, just shy of $1 million, is residual retained earnings or excess revenues over expenses that you use for subsequent years' financing. About 35% of that is in the form of the Thornhill, Miller, and Howling settlement payments. And 12% is sequestered in the GEMS fund for legal litigation, only released by your board.
What's SYF?
Subsequent year funding or subsequent year financing. Now, just to relocate your board, the fiscal model that your board gave us direction a year and a half ago to follow was, to try to match core costs with pump charge revenues and augment it with settlement or surcharge. And as you can see, the fiscal model is sustainable. Your board has also given us direction that in the upcoming study session for 10-11 to present some options to you about matching more closely fiscal core costs with operating revenues and setting aside surcharges. And we will do that for your consideration mechanically. Those are policy issues for you, but we'll give you some mechanical options. But the bottom line here is the fiscal model that your board directed us continues to not only work, but to thrive. So with that, I'd be happy to answer any questions. Our recommended action is for you to receive and file the report.
Okay, anybody have any questions for Gerard? Anybody? Okay, thanks, Gerard. Very good. Receive and file. It's
Move to
done.
receive and file.
All in favor? Aye. So moved. Okay, very good. We are down to the executive officer's report. Anybody have any questions or comments? I will make one quick comment. John Matthews gave us a briefing at the United board meeting 2 weeks ago, and about the Oxnard Plain Users Group. And I said to John prior to the meeting, and I've said to Brian and John, the Oxnard Plain Users Group is doing a great job, and I really appreciate the work you're doing, and you and Brian of steering that group down a path. And one of the issues that John raised or said to me is that there's a consensus among the pumpers. Let's not have meetings for meeting's sake. Let's have meetings when there is something actually to talk about. And Brian has done a great job, and John has done a great job of really boiling the issues down so that when they have those meetings, they actually can start making decisions. Growers go to enough meetings, and from what John has told me, and you can comment if you like, but we're moving that ball down the court. And I believe long-term that is the biggest problem area that we have. I think the Las Posas group is working to solve their problems up there, and by taking on this task, we'll get this problem solved. So, yeah, please.
Good afternoon. I'm John Matthews. I don't want to prolong the meeting, and it's been a fun meeting today. But the one comment I do want to make is that Director Mulhart made is the fact that we have tried not to have meetings, just have meetings. That was one of the first things we had at our first meeting. This will only be our third meeting. We had our first meeting, I think, Miranda, in April or so. So we had one like April or May, and then one in August. Just to briefly bring the board up to speed, what we've done is the first meeting was just to say, kind of, let's get together and we've got a problem issue, we need to solve it. The second meeting, which we held in August the 29th of this year, we set forth 12 options that we had consensus on of ways to either recharge the forebay or to bring more water into the southeast Oxnard Plain. Rather than just set another meeting, we went away from that meeting and said, okay, we've got these 12 options now. What's the rough justice cost of those options on a per acre foot? And it's taken us a while, frankly, to get those all together. Our next meeting is next Tuesday at the Camarillo Library at 1:30. You're all invited to attend. We've sent out notices to people setting forth the rough justice numbers so that they know the 12 options we discussed at the last meeting. Now we've attached some numbers to them, and the hope is that we'll be able to knock out those down to a more manageable number, so we can really start to spend some energy and some resources on those particular ones. It's going to be a slow process, I think, but I think it's a process we're moving in the right direction, and any input we can get from any of the growers or any of the municipalities would be greatly appreciated. And I would also be remiss if I didn't mention the last meeting we had some people counted 68 people. The numbers I got was a little over 70, and that is to Jeff's credit, and particularly Miranda, who spent a lot of time going over and getting people's names. We sent out a lot of notices, and I think when you get that many people in the middle of the day to a meeting, that's a good thing. The other thing that, Lynn, you can take back to United is Jim Kintosh has done a fabulous job doing overhead that I'm not in the 21st century. I'd be scribbling with a crayon up there, and he just does these great PowerPoints, and everybody walks away, and we had really good feedback. But I really want to say thanks to Miranda and Jeff for doing that. So,
okay, all right.
Any questions?
Okay,
thanks.
Very good. Other than that, we have information items. Anybody else have anything else? Okay.
Wondering if on number 9I, the letter to you with regard to the people getting their meter repaired, I was wondering what the outcome of that complaint letter was.
This 9I is state correspondence?
Correct. Not true. It was a letter addressed to Chairman Mulhart by way of United.
The one on the back side. On the back side, your copy, that...
correspondence receipt?
Yes.
We have 2.
Yes.
Oh, I'm sorry. I'll get back to you on that. I don't know the status of that.
That was November 18th, so I don't know the status of it.
Okay.
I have a little bit of information on this. We've talked with Mr. Nesland, and he is in the position of about 5 other operators here in the GMA, where he completed the meter calibration before the deadline, but he didn't get the paperwork in time. He was just a couple days late. So we've talked with him, and we've told him that from staff's perspective, we can't waive the civil penalties. But we did talk to him, and we told him we'd plan on bringing this up at the January board meeting. So I didn't have time to tell you.
In reading that, though, it appeared that he's saying that he faxed it to you and somehow it got lost in this building.
He faxed it to us the day after the deadline, and it went to a different fax machine in the building, yes.
The day after the deadline. All right, you're going to bring that on the agenda for, it's an issue we're going to have to deal with at the January meeting.
That's right.
Okay. So we'll deal with it. Okay, anybody else have anything else? We always have a meeting early in December so that I can say to everybody, Happy Holidays, Merry Christmas, Happy New Year, drink water, but don't drink a lot of water because we don't have it. And since Dr. Bachman is not here, I can officially blame Dr. Bachman for the lack of rain. So be it.
There you go.
So moved.